I double dog dare you. I double dog dare you to put some more aluminum foil on a tether. And I'm gonna remand you again. I'm gonna remand you.
Okay, you're here on pretrial diversion revocations on 23 CR 003 and 22 CR 005. What does the Commonwealth have to say?
Your Honor, this is another motion to revoke pretrial diversion. She has a 5-year sentence. Basically, she had two and a half years on 2 different possession cases for a total of 5 years. And the reason the Commonwealth has brought this motion is that she was terminated from drug court on September 21st, 2023 for engaging in an inappropriate relationship with another participant. I believe that was Mr. Williams, who's the other person, but Mr. Cross can explain it if we need a testimony.
She gonna stipulate?
We'll need testimony, Judge.
Mr. Cross, you turn your camera back on. Mr. Cross?
Yes, sir.
Raise your right hand. You swear a testimony about to give us the truth, the whole truth, nothing but the truth.
I do, Your Honor.
We're here in the case of Elisa Russell. Mr. Stockton, you want to proceed?
I will. Your Honor, Mr. Cross, are you familiar with Ms. Russell's case?
I am Mr. Stockton.
And was she terminated from the specialty court program?
She was on September 21st. Yes, she was for number 12 of the appreciation agreement.
What did she do to violate that portion of the agreement?
When each individual comes into drug court, when we do orientation, they are told not to be engaged with other clients within the program. She was warned then, and then she had been warned several times since then, and therefore she didn't abide by the rule. And on the 21st September, the judge and team decided to enforce the rule, and therefore she was terminated from drug court.
What evidence, if you're aware, brought this to the drug court's attention that she was in a relationship with another participant?
We were showed a text at the court staff meeting by Mr. Williams and her involved in the same text, very inappropriate language, and his hand was on one of Miss Alyssa's body parts. That's all I'm gonna go with that.
You have any inquiry of this witness?
I do, Judge. Mr. Cross, can you hear me okay?
Yes, sir, Mr. Bunton, I can.
So you said that was violation of number 12?
Yes, of the appreciation agreement, which has been an original rule ever since my 23 years of service has been on that agreement in 23 years of my service.
Is that a specialty court rule specific to the 40th Circuit, or is that in all drug courts?
That is statewide in all specialty courts / drug court.
But in the AOC form that has the waivers that defendants are required to sign, you're familiar with that form, correct?
Correct, yes.
Nowhere in that waiver does it mention that relationships with someone else in specialty court would be a violation, correct?
That waiver is designed to give them their legal rights. This is a specialty court rule statewide that our program has, well, basically placed since the beginning of the program.
So no, it's not in that waiver.
No, that is correct. As you know, you review them with the clients.
And so you talked about Miss Russell and Mr. Williams being warned a couple of times, right?
Correct.
So they, I guess, violated this number 12 rule and someone turned a blind eye once.
We just discovered it. They was warned at orientation, and Mr. Stevens, Judge Costello, could not be at drug court. So he stepped in as the judge that day and warned them in open court. Also, every one of the clients that day. And then the following month, which would be in September, we came without this text information, and the photo with Dakota and Alyssa was involved in it. And the judge and the team decided to enforce number 12, which is the judge and team's right to do that, and terminated from drug court.
Based off text communications and a picture.
Correct.
Those are the questions I have.
No redirect.
Is there a second document besides the AOC document that they signed during orientation? You're talking about number 12? Is number 12 on some document that she signed?
Number 12 is SPC 18, which is appreciation agreement. It's the foundation of our program.
Did she sign?
Yes, everyone signed it with me signed it also.
I just got, they talk about this AOC form. I'm just going to make sure that there's another form that she did sign. Okay. You have any other questions? Would you like to make an argument?
I would, Judge. On the onset, Ms. Russell gets waivers and is informed of her legal rights with counsel.
Get behind them.
With counsel. So if this is going to be a rule that's not only going to expel Ms. Russell from specialty court, but also terminate her pretrial diversion and potentially send her to prison, one would think a rule that important would be outlined in the waiver, or would certainly be explained in the presence of counsel. And I don't think there's been anything testified to or anything in the record that would suggest anyone from the DPA office was with Ms. Russell when she was at orientation and signed any document telling her she couldn't text inappropriately and take an inappropriate picture with another individual. So, Judge, I don't think that that would be grounds to terminate her pretrial diversion.
Ms. Russell had 2 possession cases. She made an agreement to complete the Monroe County Specialty Court in order not to be prosecuted on those. We could have had a trial. The jury could have found her guilty. She could have went to prison, but she decided she was going to go into drug court. As part of her agreement, she agreed not to engage in any relationships with any other participants. I mean, that's what she submitted to, and that's what she agreed to. There's rules in life. Some of them we don't like, but we have to follow them. So I've asked the pretrial diversion be revoked.
I'm going to revoke Ms. Russell's pretrial diversion, have a pre-sentence investigation report done, and have her sentenced on the night. However, counsel, on the night, I will consider any motion you have to probate her with conditions. If you understand what I'm saying.
I didn't.
Okay, thank you very much. Now, Dakota Williams, Commonwealth versus Dakota Williams, 22 CR 0018, 22 CR 0019, 22 CR 0021. Are you Dakota Williams? You were born in 2003. Last 4 digits, social security number. Mr. Stockton says probation revocation here.
Yes, Your Honor. Mr. Williams has 3 cases, 22 CR 18, 22 CR 19, 22 CR 21. He had a split sentence. He got 10 years on 3 theft by unlawful taking cases. And he also entered into the Monroe County Specialty Program as part of his plea. And he was violated for having a relationship with Ms. Russell.
There was the proof the same.
Proof the same.
Does he want to stipulate?
Dakota, are you willing to stipulate like we talked about last night?
Yeah.
Yes, Your
Okay,
Honor.
I'm going to go ahead and, on his probation revocation. What's your recommendation, Mr. Stockton?
I would ask the court to impose a sentence. We can always look at this at a later date. I don't know.
How-
Unless you want to impose a sanction.
Well, when will he be eligible for shock probation?
30 days.
Okay, what I'm going to do is revoke the probation. However, was there any other violation? Is drug court on there? You still on there, Mr. Cross?
Yes, I am. There are other violations as well. He had positive drug test.
You need to have Larry or yourself needs to supplement the notice of termination because it doesn't have anything else on it.
That's all we had on there.
Yeah.
So what I'm going to do is I'm going to ahead and revoke his probation, and I will consider a shock probation motion after 30 days, Mr. Williams. And that will allow, and when you file a motion for shock probation, that'll give the Commonwealth an opportunity to respond to that motion with any additional violations. I don't think there are enough violations here for me to consider anything else. So I'm revoking and we'll be looking for a shock probation motion coming in 30 days.
Yes, Your Honor.
Thank you very much. And we'll go back to the regular.
Today's the day set for a pretrial conference. Is this matter properly before this court?
So, Your Honor, I had an opportunity to speak with Mr. Henderson. From my understanding of the conversation that we had, I believe that this would be more proper for the DB docket.
All right, Mr. Flanagan, can you call next door and ask the clerk what is their pleasure? Do they want me to send the individuals there now or just give another date?
Okay.
Probably another date because
Just gonna make me a cup of coffee, please.
can you stop talking to somebody while you on my record, please? And you still not sitting up straight for me like I asked you to before we got on court. I mean, before you went in the breakout room.
All right, Your Honor.
Yes.
Okay, they set a pretrial date of July 14th at 8:30 a.m.
All right, so the court is going to set the matter, adjourn the pretrial conference I apologize. What's that date again?
July 14th.
To July 14th at 8:30. I'm also transferring the case to the domestic violence docket by the Honorable Austin Garrett. The court will note that the complaining witness is present. And therefore, Mr. Henderson, while you may appear, you're not required to appear. We will note the file that you appeared today. And then Ms. Robinson, well, Miss Stevenson, is this the case? I know you all asked me on a case. I don't know if this is it, to reduce the bond or to take away the tether, and I didn't because it was a potential DB case. That's not this. Ms. Robinson is being held on something else other than this case.
So I'm actually, I probably need my partner, and if Mr. Murad talked to Ms. Robinson this morning, because I am puzzled as to why Ms. Robinson is incarcerated right now.
Okay, well, let me bring Mr. Murad in.
If I may, Your Honor.
You may.
So Judge, on June 15th, we actually had a tether violation hearing for Ms. Robinson. I don't know if the court remembers, but this is the case where Ms. Robinson put the aluminum foil on her tether.
Oh, yeah. Okay, I knew it was something. Okay, and then I said I wasn't, but I didn't. Oh, and then so did I not give her? I didn't give her a personal bond either, did I?
I have bond condition amended to $1,000, 10% with GPS tether and house arrest.
All right. All right, Mr. Murad, we figured it out. That's why I brought you out, but
My apologies, Your Honor.
that's okay. Okay, so Mr. Murad, did you want to put your appearance on the record then for this one, or?
If I may, Judge, yes, right, Murad P. 3665 on behalf of Mr. Arlenina Robinson.
All right, so I'm transferring the case to Judge Garrett. There's a pretrial conference for July 14th. Mr. Henderson, if you want to appear for that pretrial conference, like I said, you may, but why don't you unmute and tell me, how did you log into this court today? How did you log in? Did you use the Zoom ID number or did you click my name? Unmute and tell me.
ID number.
Okay, so if you log in to Judge Garrett on the 14th, his Zoom ID number is identical to mine, except instead of where you see an 8, you're gonna make it, I'm sorry, where you see a 9 in mine, you would make it an 8. So his is 338, mine is 339, those middle numbers. So you just change that 8, I'm sorry, I keep saying it backwards. You just change that 9 to an 8 to log in.
Yes, ma'am.
Okay, with respect to Ms. Robinson, I did say that if she didn't bond out, I would readdress her bond today. Mr. Moran.
Your Honor, with regard to that, unfortunately, Ms. Robinson has not been able to post the monetary bond. She has sat in the Wayne County Jail for well over a week because of this violation. Judge, I'd ask the court to consider amending her bond to personal. I know the court is not inclined to remove the tether today, but I would ask the court to consider it. If not, Judge, we are asking for at least the bond to be amended to personal bond. She spent I believe, over 10 days in the Wayne County Jail.
All right. So any response from the people?
So Judge, I had an opportunity to speak with Mr. Henderson about this case. And from my understanding, Your Honor, Ms. Robinson is still reaching out to Mr. Henderson via phone. She's actually allegedly calling Mr. Henderson from the jail numerous of times. I know that prior to her being incarcerated for the tether violation, when she was out on a GPS tether, she was sending cabs to Mr. Henderson's home. She was also sending cabs to people he knows. She was reaching out to Mr. Henderson's children's mother and those type of effects, Your Honor. So I'm actually going to ask the court, based on that information, to keep the bond as is and keep the GPS tether with house arrest in this matter, due to the information received from the people, Judge.
Your Honor, may we be heard as to that as well?
Yeah, but who gonna talk? Because now you know y'all both can't keep talking on the record.
If we both could, that would be helpful, because Mr. Murad spoke with Ms. Robinson today, Your Honor. But so I think that both of us should represent her today.
I don't know how Ms. Ritter gonna feel about that, but go ahead.
Okay, I just really want to speak to the the contact. I was confused as to why Ms. Robinson was still in jail today, because I have received numerous text messages from Ms. Robinson where she has expressed concern for her personal safety because of the complaining witness directly and through third parties attempting to contact her, to the point where I responded to Ms. Robinson that if she was concerned for her personal safety because someone was harassing her, that she should contact the police. Again, I have messages that were sent to me via text message as well as emails. So Ms. Robinson clearly understands that she should initiate no contact with this complaining witness, that she shouldn't have any contact with him through third parties, and she doesn't want him to contact her either, either directly or through third parties, Judge. I'm gonna join my brother counsel's motion for the removal of the GPS tether, Your Honor, at least to the reduction of the bond to personal with the GPS tether, because that actually would help to provide Ms. Robinson with a necessary defense if the complaining witness is alleging that she's coming over to where he is.
Well, here's the thing.
So she doesn't want to have contact with him. She's afraid of him
Yeah, they both,
and other
let me
people
tell you what I
working at his
surmise.
behest.
Let me tell you what I surmise. I surmise they both want to have contact with each other. That's what I surmise. Now, one thing is for sure. If Miss Robinson has called Mr. Henderson from the Wayne County Jail, where all phone calls are recorded on a recorded, I don't need any affirmation. I don't need any thumbs up, thumbs down. I don't need anything.
Mr. Henderson, just listen, please.
Yes, ma'am.
If that has occurred, it's so easy to get. It's so easy to get. Like, it's so completely easy to get. What I also know is that Miss Robinson goes through a lot of stuff to get around stuff that she want to get around. Because she put that aluminum foil on that tether. She left out that house when she wasn't supposed to. She's getting into it with a person who she is dependent on because she is tethered to their home. And like I said at the bond hearing, I wouldn't get in an argument with a person who I had to be tethered to their house. I wouldn't get in an argument with them. They could say whatever they want to say to me, and I would just try to sit there and try to take it, as long as they weren't hitting me or cursing me, belittling me. And then if I had to get away from them, I just go on the porch. I'm not gonna leave the house or I go in the backyard. So listen, I never understand these types of situations. I never do, but because if somebody don't want me, I don't want them. If they don't want me, I don't want them. And so I'm not running after you begging for you to do nothing. And then I'm not, so I never understand these type of situations. What I'm saying is, I don't know who's contacted who, but please don't be silly enough to think that it's not easy to find out who's contacted who. With the flick of a pen, we can get the records. Just with the signing of a warrant, with the signing of a subpoena, we can get the records. So stop acting like we can't tell who contacted who. Stop acting like if somebody, a third party contacting another person, we can't get the record and say, you called this person on this day, this person called her on this day. Stop acting like kids on here. Let's act like some adults. If the relationship is over, it's over. Move on. Move on to the next thing, to the next person, to the next whatever, to get on somebody else's nerves. Go get on somebody else's nerves. But I'm gonna tell you this. If either one of you violate this no contact provision between now and July 14th, I am going to lock you up. If either one of you violate this no contact provision before the matter reaches Judge Garrett, I am going to lock you up. If you put something on Facebook, I'm locking you up. If you send a message through Messenger, I'm locking you up. If you send a text message, if you make a phone call, if you send a taxi, if you send your friends, your homeboy, your homegirl, I'm locking you up. Miss Robinson, if you contact him, I'm revoking the bond, the whole bond. And you're just going to be remanded to the Wayne County Jail until the case is heard. Now, wouldn't that be a shame to be remanded on a case and spend more time in jail waiting on the case to come to trial than you would be once if you get convicted? Then you get convicted, they just gonna say credit for time served because you've been serving the time. And then, God forbid, you get acquitted and you've been sitting in jail.
Can I say something?
No, you cannot.
No.
So let me say this. I don't know who the culprit is, but you better stop it. You better stop it because you're being silly. You're being ridiculous. The case is in court now. Let it be in court. If you wanted to be together, you should have stayed together. Let it be in court. So nobody is contacting anybody. There is nothing going on in the world that needs to be discussed between Darlenia Robinson and Dietrich Henderson. If they announce we getting ready to go to war, you two can't discuss it. The court is going to reduce the bond to a personal bond, but I am going to, don't shake your head at me. If you want to do my job, go to law school, get a law degree, practice for 5 years, and then run for judge. Put your cup down because we're in court and there's only 4 people on the screen that are permitted to drink anything because we're doing all the talking. So if you think you can do the job better than me, please apply for it. Because I could just let her go without a tether. That's what I could do. And if you keep talking, that's what I'm going to do.
Mr. Henderson, please stop talking.
Well, let me say this, because his behavior right now, like that whole head back, lean back, whatever, is all disrespectful. And it's all inappropriate court behavior. All of it is. All of it is. All of it is. I am going to reduce the bond to a personal bond. I am not going to amend the tether. It will remain a tether. She will be tethered to somebody's house who's going to allow her to be tethered there. And then it will also still be a house arrest tether. And then I want Ms. Ritter to confirm from somebody the allegation that she has been calling from the Wayne County Jail, because I want Judge Garrett to be aware if she has been calling from the Wayne County Jail, so that on July 14th, when there's another motion made for the adjustment of the tether condition, they can be aware as to whether she in fact was calling from the Wayne County Jail. Is there anything else with respect to Ms. Robinson from the lawyers?
Nothing on behalf of the people, Judge. I will inquire on getting the transcripts for those jail calls.
Nothing further, Your Honor.
All right. Then Ms. Robinson, when they have a tether available, they will let you out of jail, but you are on house arrest. Now, let me say this, put some more aluminum foil on a tether. I double dog dare you. I double dog dare you to put some more aluminum foil on a tether. And I'm gonna remand you again. I'm gonna remand you. I'm gonna remand if you tamper with that tether, I'm gonna remand you to the Wayne County Jail. Anything further?
No, thank you, Judge.
Nothing
All
further.
right, then we're all set. Everybody have a great day and stay safe.
Court is calling 2024 CR 3821, State of Texas versus Janessa Lynette Salazar. Could I have parties announced for the record for the state? Defense.
Greg Desmarais.
And are you Ms. Salazar? Counsel, have you received all the discovery? Did you review it with your client?
I did, and I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Salazar, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, did you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft under $2,500 enhanced?
Yes, ma'am.
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
I did. Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Punishment is to be assessed at 2 years in the state jail facility. There is a $1,500 fine. State recommends community supervision. They're taking in consideration clause number 729758. Did you understand that to be the plea? Defense?
Yes, ma'am.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a top evaluation, 180 hours community service restitution, and no contact with Walmart. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections, Your Honor.
All right, state, you may continue to confer. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, I do.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
You're my client, Judge. It's on disability. She is a mother. There's very humble in this case. Nothing that she has even tried to minimize, or she understands her role in this, and she wants to complete her probation successfully.
All right, what are you on disability for?
I have back and mental. My back, and I had surgery, and for mental, I have bipolar and
Exactly.
yeah, anxiety, depression.
All right, why do you keep stealing?
There was any reason for it. I didn't have the money.
I'm sorry,
I
what?
didn't have the money, and I shouldn't have done it. Just a Halloween outfit, my son.
Okay, so I
no
can't
reason.
understand what you're
There
saying.
was no reason at all. No reason.
All right, so why? If there's no reason whatsoever, then why are you stealing?
Don't have a good answer. There's no good reason for it at all.
I mean, well, There has to be a reason because you had to, I looked at the items and the items are not all in one location. So you have to walk around Walmart. And I think everybody may be familiar with the layout of Walmart. Crayons are not on the same aisle as eyeliner. Eyeliner is usually in the health and beauty department. So I'm trying to figure out, why are you stealing? And this is not the first time. So what's going on with you that you feel the need to take what does not belong to you?
I didn't have the money.
So why is it when you don't have the money, your go-to is, let me steal it? And it's not even a stealing of food, eyeliner. What does that have to do with anything?
That it was one of the items, correct? I'm sorry.
And then there's a theft of taking of glitter.
That was for the Halloween outfit.
All right, well,
Doesn't, I'm sorry.
and how old is your children?
My son is 4.
4?
Yes, ma'am.
All right, so 4-year-old is not going to know if they don't go to Halloween or not and go trick or treating from door to door. But I think a 4-year-old will know if their mom is not home because she's at the prison for stealing.
Yes, ma'am.
And then who are the nails for?
I don't, I guess maybe for myself, I'm not sure. I don't remember exactly, but I don't remember those items that have me on it.
Do you remember any of the items that you took?
I don't remember exactly, but I believe that there was makeup for my son's outfit, which was a wolf outfit. And to be honest with you, it was.
What does the glitter come in on a wolf outfit?
That's what I don't recall that.
Unless it's Twilight.
Twilight is actually,
No, Twilight is Twilight is the vampires where they added some sort of glitter that is not in any of the vampire lore that I've ever read.
Yes,
but
I'm thinking maybe that was the name on the packaging for that, because it was face paint for his outfit.
All right. So how are you? Who all lives in the house with you?
My son, my youngest son, and my oldest son, and myself.
All right. So you all are just living off of your Social Security?
I did help with the assistance with housing and my Social Security, and my oldest son is actually about to be sworn in the Marines, so he's an son. And yes, that's pretty much what I live off. Yes, ma'am.
All right. You can't steal. It's against the law. And now they're asking for no contact with Walmart, so you will not be able to go to Walmart.
Yes, ma'am.
It's probably going to have to be Target or Sam's or Costco somewhere else, but no longer you're allowed to go to Walmart. You understand? And that means any Walmart. With regards to the $1,500 fine.
Your Honor, she is indigent, as she just stated. I would ask if you could waive or hold that in abeyance.
All right. The court will sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $1,500 fine that'll be probated. Take in consideration 729-758. There should be regular reporting by Zoom or in person. Regular random UAs, proof of employment or SSI within 30 days. There's to be no employment as a home health care provider with minors. Court is going to order 180 hours of community service restitution. I'm going to order parenting classes. Once she's completed the parenting classes, the community service hours will be deemed satisfied. There's to be no contact with Walmart. Field visits, 1 time per month for 3 months. Was Child Protective Services at all involved? We can do a MIC evaluation out of custody.
Yes, ma'am.
All right. And then the system is down, but normally for a state jail felony, the court costs will probably run about 300 to, I'll say, 380.
Yes.
If for some reason she's unable to pay that, you'll just have to submit a letter.
Yes, ma'am.
Okay. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? All right, we can go off the record. Here's the thing. When you want things, you got to work for them. If you don't have any money for it, you would probably be shocked. Sometimes you go up to somebody and you say, hey, I don't have any money. I'm on SSI, or this is what's going on in my life. I'm trying to make a costume for my son. Somebody in Walmart probably would have said, oh, this is $10. Here you go. I'll pay for it. I've seen people do that all the time. But now what you've done is you set yourself back, because now you have to do all of this. And you don't understand. It appears that you don't understand. You're not allowed to steal. I would have ordered a course for you, but I'm going to give you the course now. Don't take what doesn't belong to you. Period. And then there's a criminal trespass. I believe that's the criminal trespass as it relates maybe to Walmart. Here's the thing. When you have something that's a criminal trespass and people tell you you're not allowed back here, don't go. If you do go to a location and the owner asks you to leave, leave. That's your two courses that I'm giving you. Do you understand?
Okay.
In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court. All right, good luck to you.
Thank you.
You're welcome.